was pretty sure that I wasn't going to be able to get a PowerPoint to work. So we do have handouts, just a one-page handout going around, which should come to you by the time I start referring to it. Okay, well, I'm so thrilled to be here. What fun to be able to talk about this, and what fun to hear all TR had to say and the interesting things that he brought up about healthcare and about ethics. This is an ethics talk, and I would be having a really good time if I were going to be talking about ethics. But I do want to emphasize that I'm really not. That is, I'm not up here to talk about what healthcare should be or could be, or whether the healthcare law that we have is a good one or not a good one. I'm really here, as I understand it, to guide us through, briefly, this really kind of specialized, narrow little universe of the Constitution of the United States, because that is the reason that we have these healthcare challenges, and it's the Constitution that we need to understand to be able to know what's going on in these Supreme Court arguments and cases that are coming up in just a couple weeks. And so we're talking about constitutional challenges to that healthcare law. I mean, that's why they're there. And this is going to seem kind of basic, but I'm going to start with this. It's helpful to just think back for a moment about what our federal Constitution is. It seems obvious, but what is it really? Well, it constitutes, right? It's a constitution, it constitutes our government of the United States. And so when we're talking about these constitutional challenges, we're talking about challenges based upon what this document says that was written all these many years ago, but that we continue to agree to be bound by today. And so in addition to, or primarily setting out the government of the United States, the Constitution lists things that the federal government can do. And the two that are a primary issue in the cases are the powers of the federal government, Congress, to tax people and to spend money, and then also to regulate the national economy, make rules and laws that pertain to things that travel in the national economy, prices in the national economy, things like that. And both of these powers are explicitly listed in the Constitution, and they were actually primary motivators for having a Constitution at all. It was because the federal government lacked these powers, and the states were running around fighting with each other and not getting things done, that the Constitution got written and these powers got written in. So that's the background to that. As far as the constitutional challenges, you can have a constitutional challenge in a couple of different ways, a federal constitutional challenge. You can be looking at the federal Constitution and you could be saying that the Constitution says the government can't do this. So for example, the Constitution says Congress shall make no law abridging the freedom of speech. So a law could say, no criticizing the government, and a constitutional challenge would be, well, wait, there's a part of the Constitution that says governments can't do that. Another constitutional challenge is one that says that the Constitution does not permit, does not affirmatively give the power to, and then here we're talking about the federal government, to do what it wants to do. Okay, and so it doesn't say don't do it, but it doesn't say you can do it. Okay, and this is the challenge that is to the healthcare law that we're going to see in a couple of weeks. It's the, it doesn't say you can do it type of challenge that's going on. All right, and I'm going to get to the arguments, but before I get to that, it's helpful, I think, also to understand two key principles that are so very important to the Constitution itself, the federal Constitution, and to these cases challenging the healthcare law. And the first of these is this principle of so-called federalism. Okay, now the federal Constitution doesn't say that word anywhere, but everybody knows that that concept is built into the Constitution, runs through it, And there's actually an amendment to the Constitution talking about reserving some powers to the states. Okay, but the concept of federalism is the concept that everybody agrees about, which is that the federal government establishes, the federal Constitution establishes a federal government that has certain powers that are listed in the document. And so the federal government can only do something, we're talking about all three branches, if it actually has that power given to it in the federal Constitution. Now, by contrast, states and local governments can do things, and they don't have to point to the federal Constitution and say, oh yeah, we can do it. Instead, they can do what they want to do, and the powers are reserved to them to do it, and so long as they don't do things that conflict with the federal government. So that's a difference there, and that's the federalism concept. The other concept or principle that's in the Constitution that's a big deal, often and certainly is a big deal with these cases, is the principle of separation of powers. And here we're talking about the powers of the federal government and the fact that the Constitution of the United States establishes three separate parts of the federal government in its first three articles. Article 1, Congress, Article 2, the President, and Article 3, the courts. And in this document that establishes our government and says what it can do, it sets out separate things, we know this, for Congress, the courts, and the President to do. And so, pursuant to that Constitution, it's Congress that makes decisions about policy. Okay, these decisions about, well, what should the law be? Should we have this type of law? Should we not have this type of law? Should we have different types of ideas? Those are the decisions that Congress makes because the principle is we have a democracy. Okay, and so it should be the voters who are deciding it, and Congress makes those. The role for the courts then is to interpret what the Constitution means. Okay, and so that's why we see this as being this case, obviously, as pitting both the President and the Congress against somewhat, or at least the possibility is it's against the court, because the court is the one who decides whether the Constitution gives Congress the power to do what it did. Now, obviously, Congress says we think we have the power, but it is the courts that ultimately get to say that. They interpret the meaning of the Constitution, and so that's where we are. What are we talking about? We're talking about the Affordable Care Act, right? I think we all remember the months it took to pass it, the debate that went on, passing it once and then needing to pass it again in different sorts of ways. So this is a law that Congress thought about and fought about for a long time. And ultimately it got passed, and then on the day that the President signed it into law, that's when the lawsuits began to be filed challenging it, again making the argument that it was outside of Congress's power to pass this thing in the first place. Okay, and so we see these things in the Supreme Court now. Finally, all of these cases started out in federal district courts, so we have decisions by individual federal district court judges, and then they've all worked their way up, or a number of them have, to circuit courts, where 3-judge panels have rendered decisions as well. In those decisions, often, the panels weren't unanimous, and so we'll have decisions where there was a majority decision and then a dissenting decision. And so all of these things are available and out there, and possibly influencing things that the court might end up deciding. Okay, and so ultimately, we do have this before the court, and I have to correct Paul, I said this in my op-ed, but it's now up to 6 hours of argument that the Supreme Court is going to devote to this. Just very recently, they added another half an hour to the tax issue. And so that's going to happen in a couple weeks. All right, so what I have, I think it's probably gotten passed around now, I hope, is a brief outline of the questions that are before the court in this case. Okay, and I'm going to go pretty quickly because I want to leave time for lots of questions. So hopefully it'll be enough to give you an idea of the things that you're going to be hearing about. Okay, 4 questions that the court decided. It's 2 cases in which these questions arose. These cases were filed by individual taxpayers and individuals who didn't want to have to purchase health insurance, and they were also filed, as Paul mentioned, by a grouping of states challenging it as well. Okay, and so 2 key provisions of the healthcare law. It's over 1,000 pages long, but it's 2 key provisions that are the subject of the challenges. Okay, and the first one I'm going to talk about first, not because it's number 1 on the Supreme Court's agenda, but because it's the one that's gotten the most press and talk about it, and that's the minimum coverage provision, or also called the individual mandate. Okay, and this is what TR was talking about as well, as being something that in one form or another exists in other places, but here it is a new thing. And so how does that work in the healthcare law? It's a provision that says that everybody who isn't otherwise covered by insurance somehow, by a government benefit or by their employer, must have a minimum level of health insurance, or, and then this becomes relevant, so that's why I'm going to tell you about it, or they have to pay a certain amount of money on their, as a tax penalty. With their taxes. It's written into the tax code, and that is the way that this is enforced, that people have to get this insurance. History of the provision, why is it there? Because Congress did deem it essential to have an expanded base of people paying for insurance in order to enforce the other mandate, which is part of the law, which says that insurers have to cover people who they wouldn't want to cover, who are high risk or have things like pre-existing conditions. And so Congress made the determination that this individual mandate was essential for that, and that's why it did it. What's the challenge to this? The challenge is that the federal government, Congress, must have a listed power to do this thing, require people to buy insurance or pay a tax penalty. And the argument is that Congress doesn't have that. Okay, fairly complex, long decisions, lots of words about whether this is true or not. Very simply, what does a court look to, and what will the court look to when it figures out whether, in fact, Congress has the power to do this thing? First of all, it's going to look at the Constitution, right? And that's the part I reproduced for you here, which is sort of the 2 sides of the arguments about whether Congress has the power to do this, or whether the Constitution allows Congress to do it. And so Congress says, well, we have this power to regulate commerce. It's written into the Constitution, and that's what we're doing. We are regulating health insurance because it's very pricey, and it's very pricey unless it's delivered in a way that we want to change. We're regulating the national economy, the access to products, the availability of products, the price of products and services in the national economy. We have the power to do it. And by the way, there's another clause in the Constitution that says Congress can use any necessary or proper means to achieve its objectives, including regulating commerce. The other side of the word argument is, I reproduced here, the closest to anyone can come, I think, to finding it in the Constitution, would be the 10th Amendment, which reserves the powers, as I said, not given to Congress, to the states. Okay? So the argument would be that the states have these powers that Congress doesn't have, and Congress doesn't have the power to regulate in this way. Structure of the Constitution, we've already I've sort of talked about that. Courts will look at that. Structure of the Constitution, again, Congress relies upon the fact that it's a democracy, and we are a democracy, and Congress can make a policy choice whether or not having this type of provision to regulate the economy is an appropriate thing to do, and it's up to the electors and voters at the ballot box to say whether it's a good thing or a bad thing. Again, those who are challenging this would rely upon this concept of federalism, saying that the power to do this, impose an individual mandate, is reserved to the states. And then also the court will look at its own cases and the history. And I guess this is where we get to probably the meat of what the challenger's argument is, which is Congress has never done this thing this way before. Okay? And so it's a different way of doing things. Congress hasn't required people to purchase a private product. And so it's unconstitutional for that reason. And additionally, the challengers argue that there's a distinction between Congress regulating an activity, like going out and buying something, and the inactivity of not buying something. Okay? That's the argument that those Congress supporting the law would say, indeed, that it's true. Congress hasn't done this exact thing before, but it's an unusual problem, and the court has said that Congress can do things in different ways in other cases that it hasn't done before. That's the minimum coverage provision. I'm going to tell you briefly about this other challenge. I don't think it hasn't gotten as much press, but it is the one that's at the heart of the states argument. Okay, there's about 26 states signing on to challenge the so-called Medicaid expansion. Okay, and this is an exercise of a different power of Congress's. It's not the power to flat out make laws like the minimum coverage. This is Congress's power to tax everyone, collect the money, and then spend it to achieve a purpose that Congress thinks is appropriate. Okay, and so Congress's power to spend money is broader than its power to just make laws. It doesn't have to point and say, oh, we can regulate commerce. It can say, we're spending this money because we want to help the general welfare. Okay, what's the claim about the problem with this Medicaid expansion? Well, essentially what Congress says to the states through this is it says, well, you have to expand Medicaid now to cover a lot more people. And it is a lot more people that would be covered under this provision. And it says, if you want money from the federal government for Medicaid, you must do this expansion. Okay? The court said this is fine, generally. The states say it's coercive. Their argument is that, although many times Congress can do this thing, say, you must do this or we won't give you money, this particular expansion, they say, just goes too far. It's threatening to take away all of the Medicaid in order to enforce just one provision. And again, they argue it goes too far. I have to note about this argument that it's a tough one, I think, for the states to prevail on. The court has interpreted Congress's spending power very, very broadly. And were the court to go a different way on this, it really would change the law a lot. Number 3 is a brief one, and this is the second question the court would have to address. If, in fact, it said that the minimum coverage provision was unconstitutional, the question would then become whether the whole law falls down, all 1,000 pages, or whether it's possible to excise just the part that the court finds unconstitutional and keep the rest of the law intact. Okay, you can probably see how that's a complicated question because the minimum coverage provision is so important to the other part, which is key to the law as well, which is requiring insurers to offer coverage. So it'll present a big, complex question if, in fact, the court ends up getting to it. So finally, we get to the sleeper issue here, which nobody looked at for a while, a long time. And as a matter of fact, didn't look at it, so the Obama administration, which initially was arguing this, dropped it and said, oh, well, we're not going to argue that anymore. And then some of the judges and courts picked up on it. And so neither the Obama administration nor the challengers to the healthcare law want the court to go this way. And so neither of them will argue it. So, in fact, the court appointed a lawyer who happened to be one of my co-clerks when I clerked for Justice Powell to argue this provision. And so for an hour of argument, he's going to make the case to the court, bringing up the arguments that the council don't want to make. It's a very, very complex law, and it's really old, and it has to do with the tax code, so please don't go to sleep. Briefly, what it says, and I've reproduced it here, is Congress has written this law that says the court can't decide a challenge to a tax assessment until it's assessed. Okay, so it's really kind of a simple provision, and Congress has the power to tell the court what it can decide. And so this provision could actually take away the power of the court to decide the minimum coverage question, which is way up here on the top. Okay, it's not clear which way the court should go on this. There's lots and lots of good writing, really, on either side about whether, in fact, what's going on here is a tax or not. But I guess what I want to point out is that there is discretion for the justices as they look at these questions. They're not clear-cut. And this one isn't either. And so it would present an opportunity for the justices to decide to, some group of 5 justices at least, to gather together and decide that they're not going to decide the big questions. Instead, they're going to wait. This would be 2 years until the tax actually gets assessed. Thanks.